So Scott, in a recent transcript ruling, Vice Chancellor Laster set out some guidance on deal terms that might allow companies to win a motion to dismiss litigation challenging a merger agreement. Could you discuss that decision and its effect on how companies negotiate these contracts?
I think what Vice Chancellor Laster was getting at was that it is possible to resolve with money damages in a post-closing proceeding disclosure claims if they in fact prove to be on highly material issues. What the Delaware Chancery Court, I think, is getting more and more skeptical about are disclosure-only settlement claims that result in significant plaintiff's lawyers' fees and seek to enjoin a transaction on that basis only. And what Vice Chancellor Laster is suggesting to participants in this marketplace is that it's not necessarily the case that a preliminary injunction is the only solution to avoid misleading investors in what is allegedly a deficient disclosure document like a Schedule TO or a proxy statement. In fact, what he's saying is if it's a super material disclosure omission, even that can be solved with damages post-closing. If it requires people to have the information they need in order to make a decision as to whether to vote for a deal or to tender shares, we're going to require that disclosure be made before the deal is voted on or before the tender closes. But in most cases, those disclosure violations, alleged violations, can be dealt with money damages post-closing. And if in fact, in the hearing post-closing, the court determines that the disclosure violations are completely immaterial and the case being brought is not meritorious, he has no problem dismissing the case without any damage resolution whatsoever.